O1 stated that suspect was immediately terminated after viewing the surveillance. So that's what they say happened. There wasn't I'm trying to stop her from falling. No, it's saying that you threw a child to the ground. And how old is this child?
She was 3.
All right, who throws it?
A woman stands in front of Judge Boyd in a Texas courtroom, accused of hurting kids she was supposed to take care of. But then, the judge watches a video showing her throwing a little child to the ground. What started as a simple hearing suddenly becomes very serious. You could feel the air in the room change. Everyone was shocked. Judge Boyd doesn't play around when it comes to kids. She can spot fake tears and lies right away. No excuse can justify hurting a child. What do you guys think? Should the judge forgive her or teach her a lesson? Let's watch and find out.
Court is calling 2023 CR 10226 State versus Frederica Simone Nelson. Can I have parties announced for the record for the state?
Defendant for the state of Texas.
Defense.
Grant Hardy for the defendant.
And are you Miss Nelson?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Nelson, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Nelson, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with injury to a child or elderly disabled with bodily injury? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes.
Did you understand by entering this plea you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, is there an application in this case for deferred adjudication or no?
Yes, Judge.
All right, so are you all opposed to deferred or silent on deferred because it's not in the plea paperwork? Is there an application for deferred on this case?
Not be, Your Honor. The plea agreement is for 4 years prison to be probated for however long the court.
Judge, I'm sorry. I'm going to have to confer with my client.
Sure. All right.
Judge, I'm sorry.
Yes.
We have, I just mucked up on the deferred.
Okay. So does she want to apply for deferred or not?
No, Judge. No, the agreement is straight probation.
All right. All right, counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Nelson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishments be assessed at 4 years in the prison. There's a $1,500 fine. State recommends community supervision. There is no application for deferred adjudication, and there's to be no contact with the complainant. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
And then that one can go away. Okay. Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be 80 hours of community service restitution, anger management, MRT, TAP evaluation, the follow all recommendations. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Honestly, I don't think people like this should ever get probation or another chance. Some acts are just too heartless to forgive. If you can do something this cruel, it says everything about your character. No apology can erase that. Judges try to be fair and kind, but sometimes that kindness gets taken advantage of. The system tries too hard to help people change, even when they don't deserve it. I'm not saying everyone should stay in jail forever, but some crimes tell you exactly who a person is inside. If you can hurt a child like that, why should anyone believe you'll suddenly change because the court went easy on you? I'd rather see real punishment than another slap on the wrist pretending to teach a lesson. What do you think? Is mercy the right call, or is the system being too soft?
Review the waiver and consent to stipulations with your attorney. Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. And state, have you had any contact with the complainant? All right, thank you. And you may be excused. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Is there anything you wish to say on behalf of your client?
No, Judge, I don't think so.
All right, so why are you doing this?
When I wanted Emiliana to get down, instead of me pulling her and putting her down like the way I did, I could have did other ways. I could have either played the game with her. We could talk.
No, that's not what it says. What you're telling me is not what's in this police report. What it says is this child came home from this early learning center. O2 stated she picked victim up from the listed location yesterday at approximately 17:30 hours and found victim crying. O2 stated that victim told her that suspect that she made her cry. O2 stated that she confronted the suspect about the incident, and the suspect denied anything happening. O2 stated that she then advised suspect's supervisor of the incident and requested that the video surveillance of the location be checked. O1 stated that the video surveillance was checked this morning, and the video showed S1 throwing V1 to the ground. I then witnessed the video that showed S1 sitting on the ground, attempting to clean a cabinet, and the victim was standing in front of her. Suspect then can be seen throwing the victim aggressively to her side and the victim hitting the ground. O1 stated that the suspect was confronted this morning and asked about the incident. O1 stated that S1 told her that she attempted to move the victim by her arm. O1 stated that suspect was immediately terminated after viewing the surveillance. So that's what they say happened. There wasn't I'm trying to stop her from falling. No, it's saying that you threw a child to the ground. And how old is this child?
She was 3. 4.
All right, who throws a 3-year-old to the ground?
So she was on the cabinet, and I wanted her to get down. So I grabbed her and I put her down.
No, they said you threw her to the
That's what I'm
ground.
saying. I didn't throw her down. I took her by her arms and I landed her down. And then I got over her and I told her to get up.
Now, where's the
That's what
video?
I'm saying.
Does anybody want to offer the video into evidence? Does anybody have the video?
Because when the CPS lady,
All right, just 1 second. We're going to see the video. I always say, show me the video if you have the video. Is there any objection to the court reviewing the video?
No objection, Judge.
All right, let's see the video.
Let's be real, her excuses don't make sense. When someone tries to defend something that awful, you already know they're in the wrong. People always blame stress, tiredness, or even the child's behavior. But that's not taking responsibility, that's just deflecting. What's sad is how often adults hurt kids and then act like they're the victims. The system sometimes treats tears like they're proof of regret. That's why people keep pushing limits. I don't care if she apologizes or cries, her actions show who she really is. And the judge's face says it all. This is a perfect example of how people use emotions to escape real consequences. Do you think our justice system is too forgiving, or not strict enough? Then the hearing continues. The judge asks if she has kids or grandkids. She says yes, 4 kids and 6 grandkids, one just a few months old. The judge then asks, what would you think if someone did what you did to your 3-year-old granddaughter? The woman admits it should never happen. But the judge points out that her story doesn't match what's seen in the video or the police report. Then comes the sentence. She's given 4 years in prison, suspended for probation, and must serve 90 days in county jail. She also has to complete anger management, parenting classes, 100 hours of community service, and can never work around children again. She's banned from babysitting or having unsupervised contact with any minors, even her grandkids. When she says she has mental health problems like depression and psychotic episodes, the judge orders a mental health check. The judge also criticizes how daycares hire people without background or psychological checks. Before ending, the judge warns her, if you ever get angry again, walk away. Count to 10. The woman agrees, and court ends. What really shocks me is how easily people lie until the truth hits them. The second that video played, her whole story fell apart. And that shows exactly who she is. Too many people think they can cry their way out of trouble. The justice system gives chances to people who truly change, but this wasn't regret, it was just fear after getting caught. I'm tired of seeing fake tears the moment people realize they're in trouble. It's not accountability, it's performance. If she can lie in front of a judge, imagine what she's like when no one's watching. Society keeps forgiving too easily. What do you think about this case and the judge's decision? Let me know down below, and don't forget to like, comment, and subscribe.